children live, they don't get that primary residence deduction, and so that's a problem. And if they simply let it pass through their estate or did a life estate deed so it doesn't pass until their death, then the children would get that step up in basis.
So it's always better for tax, from a tax standpoint,
Right.
to inherit property. Because you're inheriting it at the value at the time of someone's death.
It may be an
Yes,
issue, interesting this year,
Yeah.
because this is the year of the unlimited
Yeah.
Right,
tax for estates, but there's also no step up in basis for capital gain purposes.
We could address that topic when we talk
that's a
about
long
elder
topic,
care. Yes. Under what circumstances would someone actually want to go through probate rather than, because of its tax advantages, rather than having something held in joint tenancy? When would they ever be in an advantage and want to go to probate? Is there any time when that would happen?
Well, I think the reason why people have trusts or create trusts is to avoid the probate issue, but more importantly, to avoid tax issues.
Right. Yeah, I mean, depends how big the estate is.
Yeah.
And
Yes.
here, what we're talking about is taking property between a husband and wife and dividing it up so that one spouse owns half the property and the other spouse owns the other half, so that it can then go through a trust or probate or an estate tax return, so that you get the full deduction that each person gets. Now, it's hard to talk about this year because of the unlimited amounts, but in Rhode Island, we just know it went from $675 to $850, so that each party can deduct $850,000 before there's a tax due on death. And so you want to divide the property up to take advantage of both spouses' deduction.
And then when you're determining what your taxes are, your estate taxes, you have to include all of your probatable assets and all of your non-probatable assets in figuring out what the tax is. So getting back to David's example earlier, your life estate, your life insurance, you would count that.
Even though it doesn't pass through probate, it's part of the value of your estate at death.
Well, as we're getting ready to talk a little bit about the changes that are taking place, how about on the other side when someone simply has very little, under 20, under 50,000, I don't know what the cut off is, but there's something that's called a set-aside. What does that mean? When someone doesn't have to go to probate, they just have it transferred because it's a simple event and they refer to it as a set-aside?
Well,
special administration.
in Rhode Island, we have a small estate statute, I'd call it, that says you don't have to go through the formal probate process, but simply there's some forms you fill out, the clerk or the judge looks it over and signs it, and then you take that to the bank or whoever has the asset, and it transfers that way.
That's the point, I
The
guess.
limit in Rhode Island.
15?
15. In Massachusetts, it's 25,000. And they call it voluntary administration in Mass.
I
Okay.
think it might be the same.
Okay,
Yeah.
good point. Okay. What about the tax, no, let's go through the actual probate process. We were going to address that earlier. What is that whole process about, and tell us how you can step us through that. It seems like it could be a daunting task, perhaps, just gathering the material, but can you help us with that a little bit?
You want to start with that? Or
In order to probate an estate, let's say right from the beginning, somebody passes away, they leave a will. The will needs to be filed with your probate court in your city or town where the decedent lived at the time of his or her death. Okay. In Massachusetts, it would be the county where the decedent lived at the time of his or her death. The will has to be filed, the original will, unless you can't find the original, which is a separate topic, but the original will has to be probated. It has to be filed with the probate court. There's a statute that says it has to be filed within 30 days from the date of death.
Yeah,
Well, that doesn't often happen.
Yeah, most people never get to that because
Yeah.
they're still dealing with all the issues surrounding the person dying.
It's
and all
virtually
of
an empty statute because
Right.
I don't think the probate court enforces that,
Yeah.
I think, unless somebody deliberately withholds a
that.
will.
Right, which would be a different
Yeah.
issue.
Who files it?
Either the person designated as the executor or the executor will
Hire an attorney.
hire an attorney. The attorney fills out a petition for probate, which is just a form that you can get off of Rhode Island Secretary of State's office. And simple form is name of the decedent, address, the heirs at law,
The executor.
and the executor. And then that gets, there is a filing fee in Massachusetts. I don't know the exact fee would be in Rhode Island because it depends on
it's
cities
size
and
of the
towns.
estate.
Yeah.
It's 1%.
And the size of this estate, yeah.
With a minimum. So if you don't know the size of the estate, generally you might send the minimum amount in.
Which would be what?
$35, I think,
Oh, okay.
filing fee. And then there's cost for advertising that's on top of that. You might almost reach $100 if you're paying the minimums.
That advertising, is that what's posted as a legal notice?
Correct.
It's a legal notice to let the whole world know that John Doe has died on this date and a petition for probate has been filed with the city or town of, and X person is being named as an executor or executrix. If anybody should object, they give you a deadline to object, okay? They set a court date, and that would be the day where somebody would object, and typically what happens is that this person's just appointed the executor.
Right. So the creditors might get notice that way, but Rhode Island also requires the executor to give notice of the filing of the estate to any known creditors.
And the heirs, we give copies to all of the heirs.
Notice to the heirs.
So that executor or that next of kin who's holding the document or even holds the papers, the deceased's mail that says he has a Macy's credit card, he has to inform them that there is a probate date being set, and only at that time will they get paid, or do you pay them before? How does that work?
First, what happens is the person has to get appointed to be the executor.
And how does that happen?
At this hearing.
Okay.
And generally what happens is a will have what's called a self-proving affidavit in it, which is an affidavit of the witnesses that the person who signed the will was a full sound mind and full age, 18. And then the affidavit and the will are looked at by the judge and the will is admitted to probate. Then there's a 6-month period of time for creditors to make claims. So it's during that 6-month period of time that the executor can gather up all the assets and find out and gather up all the bills or claims against the estate and determine that there's enough money to pay those and start paying them out. And you want to get releases from every creditor that files a claim so that when you want to close the estate, you have all your documents in order.
There's also a list of priorities in terms of creditors, who gets paid first. The first is the funeral
bill.
The funeral bill,
Right.
Maybe Uncle Sam comes next.
Then the cost of administration of the estate.
David said it's 6 months. In Massachusetts, probate is open for 1 year. Doesn't always mean, even in the 6 months, that the estate's going to close in 6 months. I think the 6 months is there for a period of time for your creditors to file claims.
Right.
And it's 6 months from the date the executor is appointed?
Yeah, the date the will is admitted to probate.
Okay.
So if someone is supposed to contact the heirs, maybe they can't, don't know how to reach all of the potential heirs or the potential
that happens.
beneficiaries of it. Are they covered just by listing that little legal notice?
No.
Or in 6 months, maybe it takes longer for someone to come out of another state, country, or whatever, and find out that so-and-so passed away?
Well, there's a couple of things. The easiest way to get a will into probate is to have all of the heirs sign a waiver of notice so that they're not acknowledging they know about it and they don't need specific notice given. If you can't locate all the heirs to do that, you can advertise, but there's also services that lawyers can turn to track people down, the missing heir service, so to speak. And that actually exists. And
that's bona fide, really?
Yeah, and you need to do that if they're an heir under the will and they're going to receive property, because they have to be given their property, and you have to get a receipt or a release from them so that you can close the estate.
Now, that would assume that someone has to have a lawyer, because how would a typical representative or the next of kin have such an affidavit unless maybe they could Google it and go online and do that. But it would mean that you'd have to have a lawyer to help step you through this, correct?
Well, not really, because I think you can download that form.
Yeah,
the release can
so
be
you can do it
downloaded.
online.
All of the forms actually are online. I think you need an attorney, though, to help walk you through some of the finer points that can come up.
Yeah.
For instance, if there's real estate that needs to be sold and there's no power to sell in the will, which would give the executor the right to sell it on their own accord, you need permission from the probate court judge to sell it. And there's a process to go through that. So there are a lot of little nuances that